Welcome, everybody. This is number 3 in the 7 webinar series, Protecting Employee Assets, Lifecycle, and Employment Relationship 2026. Again, I'm Chuck Kruger, I'm the moderator. And please check out slide number 4 on the PowerPoint, which is our typical legal disclaimer that we are not your attorneys and you're not our clients, and you should not be going out and making important business decisions based on what we discussed today. This is general knowledge, and it's intended to help you make decisions for your business or to select a professional to work with when out there trying to find an attorney or a professional. And we won't be lecturing off the slides, although we may refer to the slides every once in a while. So it's not expected that you have to read off the slides while we present this. This is a general discussion of wage and hour compliance. It's a conversation between the faculty or the panelists. More about financial employees, by the way, is on slide number 45. Thanks to our sponsor, the National Law Review, slides number 3 and 51. Our panelists today, as always, we have Max Barrick, who's a partner with the Garfinkel Law Group, Helen Black of the Law Office of Helen Black, and the returning panelist, somebody who's been out there in the hinterlands, who was wayward for a while and is now back with us, only for actually one presentation, filling in for his partner. Katerinkis is Amit Bindra, a partner at the Prinz Law Firm. Welcome back, Amit.
Thank you. It's great to be back.
Thank you. And you can read more about us on slides 47 through 50 of the PowerPoint. If you're attending the live premiere of this webinar, you can submit questions using the web portal. I'll be monitoring that. If you're watching on demand and have questions, you can send an email to info@financialemployees.com. Just include your question, name of today's webinar, and we'll do our best to get you an answer ASAP. All right, so with all the preliminary stuff out of the way, let's get into wage and hour compliance in 2026. Helen, let's start out with you. How would you describe the U.S. regarding wage and hour comp laws? Is there like some sort of like a zeitgeist or overlying philosophy that you can pin down?
Yeah, for sure. You must pay your employee wages. You cannot contract around it. You can't get them to sign a waiver that they're waiving claims to certain wages. That is payment of earned compensation is one of the few areas within the employment context that is as close to black and white as possible. And there are laws, both federal, meaning it applies to every state in this country, and practically in every jurisdiction in this country that says that you've got to pay your employee for all hours that they work if they are what's called, which I'm sure we'll get into, not exempt from overtime. And if they are exempt from overtime, which we're going to get into, you still got to pay them. You can't even enter into some sort of an agreement in which you said, okay, I paid you for most of this stuff, just waive the rest that I owe you. That is not going to work. And there are very, very stiff penalties if you fail to pay your employees earned compensation. These are one of the few areas that there are attorneys who they just look for these cases. They will troll for these cases because the penalties are so stiff and so high if you fail to pay your employee their earned compensation that their attorneys will just take these cases. And it's what we call in a way strict liability. That's like a fancy word for basically saying, I don't care if your house burned down and that's why you didn't pay your employee, you got to pay them. So you can't have an excuse, no matter how good it is, that you failed to pay your employee. If you owe your employee wages, you better pay it to them. Otherwise, you could be held liable, even if you have a really great, phenomenal, compelling reason as to why your employee wasn't paid compensation that was due and owing to them.
Even if you have a great attorney like us representing you.
Yeah, what we can do is if truly the wages are owed, and that's usually what it turns on, if truly the wages are earned, we can perhaps provide some mitigation and help maybe, negotiate, a little bit to kind of help you, save a little bit. But these are very, very challenging claims to defeat.
So, Helen alluded to the Fair Labor Standards Act, talking about exempt from overtime. What is that?
Yeah, the Fair Labor Standards Act is the federal law that governs the payment of wages. There are state equivalents as well, but the federal law basically just requires companies or employers to pay a minimum wage and also has requirements in the payment of overtime. The overtime situation, I'll use that word, is not straightforward because different types of employees may or may not be eligible for overtime. And even calculating that overtime amount can be tricky. And quite frankly, even the minimum wage number or amount can be tricky because every state is going to do it differently. There is a federal minimum wage, but certain states and certain locations have a higher minimum wage. And so because of that, you kind of have to be, or a company has to be familiar with both the state and the federal law.
Thanks. Max, relative to the FLSA, Fair Labor Standards Act, can an employer just pay everybody a salary in order to avoid the overtime in order to avoid overtime?
So the short answer is no, that's not a good idea. The longer answer is paying somebody a salary does not automatically exempt them from overtime. It's a pretty common and I think frankly costly mistake that I see in wage and hour work. I like to give war stories because I'm the one attorney on this webinar that exclusively represents plaintiffs and has limited experience advising employers directly. What's that, Amit?
I think Helen used the word troll to describe you during this.
She did.
Yeah,
I think she called me personally a troll. That's employment law for ambulance chaser. No, all kidding aside, wage and hour is, I think, in general, one of the quickest places I see employers screw up. And it's not always a malicious thing. It's sort of what Helen was hinting at. People think, well, we have a handshake agreement or we trust each other. And there are just certain employment laws, like other laws in this country, where you have rights that are not, this sounds weird, but they're not your rights to waive. The Congress and by extension the courts have set up a wage system that they do not want being undercut by private agreements because they recognize there's a bargaining disparity. And so Helen already touched on this, but be very, very careful saying, well, we agreed to this or it's in writing, so it's a contract. What's the issue? A, that's not how law works. And B, it doesn't matter because wage and hour claims generally cannot be waived, like affirmatively give up your rights to pursue them without a court approving that you've settled a dispute. I'm saying all of that to say just labeling somebody salaried when they're not meant to be, when they hit a test that suggests within the FLSA that they should not be salaried, is a very quick way to get yourself sued. There's a salary basis test that somebody's got to be paid a guaranteed salary above a threshold, which seems to yo-yo every time the courts do or don't like when it's increased in a regulatory regime or there's a switch in the administration. And the duties, so I touched on this a little bit, that you perform actually have to fit within an exemption. In a white-collar setting, the most common ones we look at are I think they're often called the white-collar exemptions, the executive, administrative, and highly educated or highly paid professional exemptions. If either prong, the salary basis or the duties test fails, then you're not supposed to be exempt. And you're supposed to be getting paid overtime regardless of how they're paid or what handshake or written agreements you have. So I think, the takeaway would be you can't salary your way out of this, right? You can't say, but I said they were salaried. Like that's, all of it. The first collective I ever filed, and I think I mention every year on this webinar, is one where it was a bunch of trucking dispatchers who were technically salaried and never got paid for the Saturday meeting they did or the 50 hours a week they worked. The last 10 were paid straight time. And it didn't matter that this was in the handbook. The employer walked right into a six-figure collective action because they didn't bother to check the law on it.
And to add in on that, I think paying someone a salary doesn't mean they're ineligible for overtime. It just may mean their overtime calculation is higher because they're getting paid more money. So it's not it's not a bright line rule.
No, and the 1099 issue is a similar way to really step in it. Just calling somebody an independent contractor or writing something out ain't worth the ink the papers, that's printed on that paper, right? Or the value of the paper the ink's printed on, whatever the saying goes. You can say whatever you want on paper. If you don't hit the economic realities test and satisfy it, um, call them whatever you want, the outcome's going to be the same and probably worse because there may be IRS and state Department of Revenue implications for not withholding proper taxes on top of the liabilities you owe under state and or federal law for minimum wage or unpaid overtime violations.
Yeah, the problem with like misclassifying someone is not only may you owe them overtime, there could be issues with unemployment, workers' compensation, a bunch of stuff because employees are granted additional rights, and the IRS always wants a cut of the pie, and so they're going to want their payroll taxes.
Yeah,
And you see it, I mean, I feel like you see it a lot in very specific industries. I'm sorry, Helen, go ahead.
no, I was going to say a point that Amit made. One of the most costly mistakes by misclassifying is actually the workers' compensation, especially for a smaller business, because that is the one that really could bankrupt your company. Whereas most businesses don't want to be dinged by the IRS or unemployment because there are penalties and the penalties are steep, and I don't want to minimize that. It's a big thorn in the side. Usually the companies can pay. Usually they could take out a loan or whatnot and pay those obligations if they have to, or work out or negotiate something. The one that truly can bankrupt your company is the workers' compensation because you have no control over that. And what I mean by that is the injury is serious enough and you're personally liable. And also the business can't shield you from workers' compensation. An owner of a business can be held personally liable. If that was a catastrophic injury, you are on the hook for paying all those hospital expenses and the bills. And that, as I said, could be enough to bankrupt a business or put a business out of business because there aren't sufficient resources. And then still the person can be held personally liable. And then the state government can go after you personally to pay that claim. So that is one of the most expensive mistakes in misclassifying.
Aren't there
Well,
possible criminal consequences to not having workers' comp insurance too? Like if you don't have it
Yeah,
at all because you think everybody's a 1099, so you don't have to. Like you can't. I mean, forget going bankrupt. Like you're gonna wreck your life by
you
saving a
could be
few
held.
bucks
Yeah.
on insurance there and payroll taxes and overtime. Like that's cost
When
benefit analysis here.
And to Helen's point from earlier, I mean, maybe you can try to defend whether or not someone's an independent contractor or not. But if they're not and they are an employee, there's really no defense to everything else. It's just a question of like, you're going to have to write a check as a company. How big is that check? And now you have to hire an attorney to deal with all of this. So it becomes, you potentially could have saved a little bit of money, I guess, by doing this. And now it becomes a huge expense.
well, and there's also, I mean, there's that strict liability, that aspect of it. But then there's also there's potential criminal sanctions under a lot of state laws, wage and hour
Yep.
laws. And then there's also personal liability under the Fair Labor Standards Act too.
Yep.
So,
Yep.
I mean, there is that level of liability relative to most wage and hour laws, including the federal.
And you know, the reason my brothers and sisters, if you will, like to troll for these cases is what my colleagues were talking about here. They are pretty much strict liability. And even where they claim someone's a contractor, like this is one area of civil litigation where the lack of record keeping or these defenses really cut against you. And the presumption, it's not that the evidentiary burdens, that the obligations to prove your case are not on the plaintiff. Those are always there. But you are really going to have to overcome some burdens to prove evidence and good faith in fighting these cases off. And most you know, management specific attorneys that I talk to, when they have a client who's caught and is guilty of one of these violations, they're not going in guns blazing to knock it out because they're really very rarely a straight up winnable case. And the longer you play around with it, especially if you've got potential class exposure, the more and more dangerous this can get to your business. You just don't if you get caught speeding, don't try to talk your way out of it and fight it to the death unless you have no alternative or you really have a meritorious defense. Like plaintiffs' lawyers can get it wrong, but there's a difference between you got it wrong and you just don't want to pay. You know, and I think taking a realistic view of these claims is necessary because they're very hard to win on the management side.
When
Litigation
delaying the
strategy,
payment. Oh,
I was
sorry.
just going to say real
Just
quickly, litigation strategy takes a backseat to transactional law with a lot of these
Yeah.
cases. So, sorry,
for
Hamid.
sh- oh, for sure. And part of the problem too is if you delay payment because you don't want to pay, there's monthly interest penalties, and now you're racking up two sets of attorney's fees, yours and theirs. And if there is liability, then you've got to pay both sets.
Well, and yeah, so let's clarify that. Besides the strict liability aspect of this and sometimes criminal sanctions and personal liability, there is the attorney's fees. And oftentimes the attorney's, I find personally that the attorney's fees can exceed the liability, the actual damages, equal or exceed.
Yeah, very easily. Because now Max is going to file a claim where maybe several people are owed some money. So that can balloon. Individually, it may not be an astronomical amount, but collectively it can be. But to Chuck, to your point, then the attorney's fees become astronomically high. And so that can also, they may exceed the actual wages owed, but the court's going to look at what was reasonable to litigate the case. And so just because the fees exceed the wages doesn't mean they're unreasonable. And in fact, that's why the statute is set up the way it is, because otherwise you'd have a situation in which lower wage workers who actually need the money don't have a legal recourse because the attorney's fees are going to be too high.
Well, and
Yeah,
going back to the court approval point, like that's the reason that exists. So when we say that, what we mean is you settle an employment discrimination case, and unless I'm missing something, I've never seen this come up. Um, you know, you file a stipulation with the court if it's gotten litigated that the parties have reached an agreement. You don't have to say what it is, and it gets dismissed, and nobody really asks questions. However, in a wage and hour case, and the management side actually typically wants this because you want to know, especially if there was a collective or class action, so there was a group on behalf of all the employees, that you've knocked this off, that it's not going to come back to bite you again. No one's going to come out of the woodwork. You're not going to get hit with 7 or 8 more kind of trickling in claims down the road, that this is everybody. So, one of the pitches I make to the other side when I do file one like this is if your client wants to resolve this early on behalf of the group, they're not going to see it this way, but it is to their benefit because the less work they make me do, the more reasonable I can be with my clients on the penalties. But also, you're going to close the door to future ones. If you play games and you wait around too long, or you make us fight it, or these things happen, more people tend to come out of the woodwork. But on the court approval point specifically, the reason for that is the courts want to look at this and say, especially if it's a class action, but even if it's individuals, that the lawyers didn't get into a cigar smoke filled back room and cut a deal to settle it cheap for their benefit, that the clients are walking away at least with what they were owed, unless there's some defense or other mitigating circumstance that might lend itself towards a short settlement. So that matters because if you make this case really expensive and then try to get out of it cheap and pay people less than they're owed, you might not even be able to get a judge to approve it. So the stall tactic that might work on the management side in like a discrimination or just commercial litigation dispute really is not going to lend, it's not going to lean in your favor nearly as much as it would in a potential collective or class wage and hour dispute.
Yeah,
While
I
we're
mean,
there,
great
can
point.
you do a quick just explanation of the difference between a collective and a class?
Yeah, and I mean, I think that's what can be so dangerous for employers is it's not that hard to get a collective certified, even though at least in our jurisdiction, the rule just recently changed. But the short version is when you file an unpaid overtime or minimum wage or tip pooling lawsuit under the FLSA, in other forms of litigation, you want to file a class, you file a federal Rule 23 class. There are certain procedures for when you can file for class certification, at what stage in the case, or evidentiary burdens might be appropriate. In a collective case, the way Congress wrote this law, they did it with the expectation and understanding that time is of the essence because every day that goes by, you're losing claims on the other side of the statute of limitations. There are bargaining disparities and people might fear retaliation. So we need an easier mechanism to notify people that they might have the right to join a lawsuit and their rights might have been violated. So, and I do this immediately when I file a wage and hour case like this. You can file what's called a motion for conditional certification. at the early stage of the case where you don't have to prove the whole claim. You don't really need that much evidence. You just need, depending on what circuit you're in, federally, the standard is different. But you basically need to be able to, it used to be in our neck of the woods, you need to be able to prove by preponderance of the evidence that it was more likely than not that an unlawful pay practice was ongoing, which is not at all a high standard. I have never lost one of those motions under that standard. Now, the new standard is slightly higher in the Seventh Circuit, and shame on me for not having it in front of me. It's still pretty manageable, and I haven't gotten a ruling yet, but as far as I'm concerned, I'm still undefeated on these. So, you can now you can fight certification down the road and maybe get it decertified or make it so that they're not able to fully certify the collective or a Rule 23 class. But people are going to find out pretty quick. And the more people that join these cases and get notified, the more exposure you're getting.
Great. Excellent analysis, everybody. Amit, can an employer just tell employees that, well, this is something that Max was alluding to in terms of gathering of evidence and, well, the evidentiary standards, but can an employer just tell employees to keep track of their own time and then have them submit a timesheet every week or 2 weeks?
Yeah, I think that's a bad idea. Part of it is the case law that I've seen. I don't think I've seen anything contrary. And Helen and Max, let me know if you have. It's the employer's responsibility to know how often and when the employee is working. So the employer can't say, I didn't know. That's not a good enough answer. So that's part of it. Part of it also is some state laws also require record keeping. So, for example, I think in Illinois, there's a Department of Labor requirement that you track and provide all time records. And so, regardless of whether or not the employee should be working or is not working, the employer still has to pay the employee for off the clock time and for remote work and stuff like that. So, it's just not a good idea to not record all time. It's better to record all of it to make sure that as an employer, you know all hours worked so there can't be a discrepancy later, and to have good policies around how you want to be communicating to your employees when they can and cannot provide off the clock or additional work over 40 hours.
But
And
adding on to something, though, I just wanted to clarify something Amit said, and everything Amit said was 100% correct. But I think, Chuck, when you asked the question, I just want to make sure folks know employees can't keep track of their time. The burden is on the employer to make sure the time is maintained and that they have time records. But the employee can submit timesheets to the employer for payments. I just want to make sure that folks understand that.
Yeah.
So, for example, you have like a really small employer that doesn't have a fancy time tracking system where sometimes people clock in, they clock out, there's an app, whatever the case may be. It could be, the old-fashioned way where you write it on a sheet how many hours you work, you submit it to your employer pays. That is fine. It's not unlawful so long as your employer is keeping track of your time. Now, you might not want to rely on your employee to do that. But let's say, again, you're a small employer, your employees work remote, you really don't know how many hours they're working for you. You pay them per hour. It's not unlawful to rely upon your employee to complete a timesheet, submit it to you, and the employer then pays.
Yeah,
well,
sorry, and that's 100% right. What you can do is have the employee send you the timesheet and then keep it. You should keep record keeping stuff to make sure you're in compliance as a company with, state and federal laws. A company should not do is just not have any record keeping of what the employee's hours.
all right. So let's say the employee reports that they work 10 hours and the employer says, no, that's not true. You only worked 8 hours. I mean, who wins or how do you prove who wins in that situation?
Well,
It's
good
gonna,
luck. And that's what is going to land Max trolling and finding that dispute and filing it.
I mean, go ahead, Helen.
No, I was just about to say, unless truly the employer has some way. Like, so for example, the employer has, let's say, a camera in the
Yeah.
office and sees when the employee came and when the employee left, and the employer has an idea that the individual is fudging their time, and they say, no, I see you walked in the office at such and such a time, you walked out at that time, you did not work 8 hours that day. I mean, but barring something that is pretty black and white like that, I think it'd be rather imprudent for the employer to dispute necessarily what the employee paid or what the employee alleges that they
Yeah,
worked, if
I,
unless they're 100% certain.
I
and
was just going
usually
to say it really. Go ahead, Amit.
oh, sorry. Usually the scenario is the employees doing work like late at night, sending email, stuff like that, and the employer is like, I don't want to pay for that. But the employee's argument is going to be, well, you knew I was working. I emailed a supervisor, I did this, I did that. And so because of those reasons, the employer likely is going to lose that fight, and it's going to end up costing a lot more than paying the extra 2 hours.
Well, and two things. I mean, one, who wins it really depends on what is your record keeping, right? Is the hypothetical like there's no record whatsoever? Then yeah, it's your word against theirs, what have you. But if it's like, there's case law, at least in the Seventh Circuit where we exist, that says like where there is a dearth of record keeping by the employer or poor record keeping, if the employee can give credible sort of propensity type testimony, like on Wednesdays, that's when the shipping orders came in, and I know that, yeah, I didn't clock in, but I would get pulled. I'd be walking out of the parking lot, and my manager every single Wednesday at 7 a.m. pulled me before I could get in there when I had a half hour left before my shift and had me working the dock. I have a case against somebody who owns a bunch of ice cream shops where I've got about 6 or 8 witness declarants out of the opt ins, all of whom say they had a practice of hop on the line or go do X task before you clock in. Like, hey, go sweep the front walkway, which is a block long, before you clock in. Well, everybody knew that was a 20 or 30-minute task, or go take the trash out. But if you're at the large lake based glorified shopping mall that exists in Chicago, and that's where it is, then the trash cans are, you know, half a mile away. That's a 20-minute, 30-minute task. It's not de minimis. Like, I know every Wednesday I did that. That testimony is going to carry the day. But you also need to think back to the statutory regime of the FLSA, and that is it operates under the suffer or permit standard. So if you, to what Amit was saying about, well, you let them email you or you expected responses after hours from them, if you are suffering or permitting them to work and you're not affirmatively taking steps to stop them, and you don't have some rule in place that says you will be deemed as not having worked if A, B, or C is not done, or these records are not here, or this is your obligation, you're really playing with fire standing and saying it didn't happen there.
I mean,
What's
here's
it?
where there sometimes is. Oh, I'm sorry, someone else.
Just a quick follow up. What's de minimis? You mentioned that.
So I don't off the top of my head know what the rule is on how many hours, but essentially like the way the FLSA operates, there is some wiggle room where Congress recognized, look, if your shift ends at 2:30 and you like clock out at 2:31 and you're paid through 2:30, you lose like a minute or two a week. We're not going to go nuts over that. That's not enough to constitute a violation. It's got to be a meaningful amount of time where people are actually losing hours. Again, shame on me. I don't remember off the top of my head what the hardline rule is there, or if there
I
is
don't think
one.
I don't think there's a hard line rule. I think it's based on circumstances. So for example, if an employer is constantly docking or like shutting off the clock at 5 after 7 when they're supposed to be leaving, and they're leaving at 10 after 7, that I think that's not de minimis. If it happens once, maybe that's de minimis.
Yeah, like maybe you haven't. I mean, some of the timekeeping systems are set automatically, right? Where like they're meant to operate a certain way. Maybe nobody's monitoring it. Maybe it's a mom and pop shop. Like we can all conceive of a million reasons why hours don't get logged. I used to work at a restaurant. Maybe I forget to clock in one day, or I forget to clock out, and the correct time is not there. Like stuff happens, right? Things happen, and the law allows for that to a point. What you can't have is the standard like every Wednesday, like I'm doing 30 minutes off the clock every whatever
Yeah.
I'm staying after. Like we got to clean up the restaurant, but you shut the clock off at 10 o'clock and I'm here for an extra hour every night. That ain't de minimis. That's a textbook violation.
Yeah, there's a
Well,
lot of cases out there about like donning and doffing. Basically, like
Yeah,
how
yeah.
long, like you've got to pay people, this happens at like meat factories. You've got to pay people to like get ready before their shifts. You can't just say you're not going to get paid for that. And that over time can add up. If it's 20 minutes to like put on your work uniform, your face shield, all that stuff, a lot of workers every day, that's a big number.
The problem from the employer's perspective, and this is a legitimate problem, is sometimes employees do work really slow, or they feel like they have to get to a certain stopping point or whatever the case may be, and they want to just keep working. And the employer is like, no, go home. I'm not authorizing overtime. You don't need to do this. Go home. And the employee's like, no, I really want to. I want to finish X, Y, and Z. And it's hard to just sometimes kick an employee out of work. And I do get this question every once in a while where, I have in my handbook, they're not allowed to work overtime unless they get permission to work overtime. They really don't need to work overtime. I'm really not giving them that much, whatever the work is, they really can't get it done. Or if they didn't finish it in the day, just leave. I don't need it done. What do I do? How do I get them so I don't have to pay overtime? And they just really are working those hours and not over. And that is a very challenging problem because there aren't a lot of alternatives. You could write the person up, quote unquote, discipline the person. You can suspend them for a day without pay and say, don't come in, take this time to learn how to be more efficient at the job. You could terminate the person. So sometimes it can really be a legitimate problem. But ultimately, if the person is working, as you said, to suffer permit to work, the employer is stuck with paying that overtime if the person did work more than 40 hours within a specific week. And that's another thing that sometimes will trip up employers. Sometimes they want to be nice to their employees, and the employee will say, hey, listen, I got my kid's ball game. Can I, leave a little bit early this week? I'll make up the time next week. And the employer says, sure, leave 3 hours early on Friday and stay 3 hours later next week. Well, as Max is rightfully shaking his head, that's not how it works. It goes week by week. So if you work more than 40 hours within a specific week, you've got to pay the overtime. So either what you would do in that situation is not have the employee make up the time in the following week, or tell the employee, that's fine if you want to leave 3 hours early Friday. You need to make up the time in the same week. So come in an hour earlier Monday, Tuesday, Wednesday, or stay an hour later Monday, Tuesday, Wednesday of the same week if truly you need your employees to make up that time, because the analysis is week by week. And it's not like, and week is not necessarily the same for everyone. The employer should define what they consider to be a week. A week could be, we start on Saturday, we end on Friday, or some other type of configuration. So it's within a 7-day period that the employer chooses. That's when we calculate those 40 hours. And if you work more than 40 hours within that 7-day period, which we call a week, then you got to pay overtime for any time worked above 40, which is, then time and a half.
Great, thanks. I guess you kind of touched on this, Helen. So I'll throw this out to all of you. Can the business owner or operator deduct missed time or discipline salaried or exempt employees by docking their pay?
No, that actually is a huge problem. You can lose your exemption. You can. So here's what you need to do. Like, let's say you do have a person, and I don't like to use that word salaried because as Ahmed and Max rightfully pointed out, I mean, employers use it all the time. Oh, I don't have to pay overtime, they're salaried. It doesn't make a difference if you pay a set salary every week, because it's a 2-part test, the duties and also the set salary. So assuming the person is exempt from overtime, truly, truly, truly exempt, but they're really taking advantage. They're truly not getting their work done, okay? And so generally speaking, they're supposed to work, give or take, about a full-time week of, about 40 hours a week. And it's not that they're not necessarily working, and not only are they not necessarily working about 40 hours, but they're just not getting their work done. Well, if you want to keep that exemption, you can't just lob off half a day of pay. What you would need to do is you would need to discipline the employee, and the safest way to do it is to suspend them for an entire week so that they don't get paid at all for that week. Therefore, you are not changing the pay, the quote unquote salary that you're paying to blow the exemption. Now, I know that is extremely draconian. Some would argue you could, let's say, dock someone for a complete day of pay. That could be challenging, but it might be able to be done. But certainly you can't dock like a few hours here or there, because you are going to then blow that exemption, because that's what being exempt from overtime means. It means whether I work 40 hours, 20 hours, 10, 80 within a week, I get the exact same salary every week. That's what it means to be exempt.
I think that to what you were saying, and maybe you did too, Amit, was that I think having good policies and evaluations about performance, like if it's a case of like you're just not working fast enough and hitting our efficiency stats, you may feel inclined to get a monetary like recovery for it. But like Helen said, like what you're really going to do is just endanger the salary status. Evaluate them, like paper the file in the way you would any other underperforming employee and deal with it that way, where you fire them if they commit a fireable offense and they make it through the progressive discipline in a way that's an issue, or they're engaging in time theft. But in trying to get your money back, if you will, I think is a short-sighted outcome. And I understand why it feels like you've been stolen from, but it's a case where taking it personally is really opening up a can of worms you don't want opened, is the way I think about it.
Yeah. The
Yeah,
best way to handle is with incentives. Oh,
Yeah.
I'm sorry.
oh no, go.
Is with incentives. So, for example, oftentimes folks who are exempt from overtime, they might be at a certain professional level or whatever the case may be. They might be eligible for some kind of a bonus or some kind of an award or incentive. And that's honestly the way to get someone to be, more efficient and not miss as much work, which is, well, gee, you missed, you missed you didn't perform up to expectations. You didn't earn you didn't earn a bonus this year, or you didn't get like employee of the month or some other type of incentive. And that I think really is probably the best way to try to handle it, is to incentivize folks to really perform the amount of time you feel they should be giving to the job within a specific week.
Well,
That's a great point. And I want to emphasize too, in addition to potentially losing like salary issues, stuff like that, there are state law claims that could also arise. So for example, if you dock someone's pay in Illinois, that's likely a violation of the Illinois Wage Payment and Collection Act, because you would need their written approval. And so that can create a bunch of other claims, and those state law claims often are not collective actions, they're class actions, which I think can be much more expensive to have to defend against if it's multiple people. So not only are you creating overtime issues, but then you're potentially creating other wage and hour issues.
so relative to what you're talking about, Helen, with respect to bonuses or incentives, how does that impact overtime payment? Can that be factored into their regular rate of pay for the work week in order to so they don't get overtime, or how does that work?
So if we're dealing with someone who is not exempt from overtime and they regularly get bonuses, so bonuses are considered part of their regular and continuous compensation, then the bonuses are taken into consideration for calculating the overtime. If bonuses are, for instance, in the case of a non-exempt employee, truly discretionary. So, for example, at the end of the year, boss says, we had a phenomenal year. I'm so happy with everyone. I'm giving everyone $500. That is a truly discretionary type of a bonus that would not be included in calculating overtime, let's say, the following year.
All right, so what about like a $500 employee of the month bonus?
If it's a one-off, no.
But
No, but if it's, let's say, if let's say, for example, the employer has some type of a system whereby, for sales, for example, like let's say employees are paid per hour, and for every sales you make over 20 in a day, you're going to get this type of bonus. So this way, it's really part of the regular compensation that employees routinely get bonuses. What you would do is you would look in, let's say, the past 3 months, what those earnings were. And that is how you would, I believe, calculate the overtime. I'm not sure on the formula, so don't quote me on the formula. But the bonus really has to be regular and systematically part of the regular compensation, that these bonuses are part of the, essentially the overall compensation package that the employee receives in order for it to be considered part of the overtime calculation.
I think an example of what you're kind of hinting at, it's not a bonus per se, but it is sort of this supplemental compensation. Apple got sued by, I think it was Nichols Castor out of Minnesota hit them. It was, they had given stock options to their employees, but it had not been factored into their regular hourly rate. And so when there were overtime claims, they ended up, I think with a nationwide collective, or at least out of California, if memory serves, on that very issue. So, and for once, I actually was sympathetic to the employer there. I was like, oh, they were trying to do a nice thing. But, the law is the law in the FLSA. And if you're going to give these options, you have to consider that depending on how it's paid out, you need to factor that into that hourly rate. So the one-off like Christmas ham bonus Chuck's alluding to, yeah, that's maybe not it. But more to what Helen was talking about, stuff that's customarily part of your wage. You sell commissions need to be factored in. Wage and hour is complicated. It's not the kind of thing that you can kind of do by the seat of your pants. And the other thing is, for some reason, a lot of small business owners seem to think their accountants are also employment lawyers.
Yeah.
And
Well, there are payroll providers too.
oh my God.
Yeah.
The road in litigation is littered with the corpses of these businesses that I see, small ones usually, whose like accountant decides they're gonna play lawyer this week and tells them what they can and can't do. And it's like, guys, that's not what the law is, and this guy ain't a lawyer. So I don't know what you think you're doing, but like don't let your accountant tell you how the FLSA works. And I don't mean to disparage accountants. I know that's a very technical degree I couldn't do, but you're not an attorney, and these are really dangerous laws to be freelancing with.
When what's
I'll give
likely
you
going to
guys a.
happen now
I'll
is,
give you a.
oh, sorry.
Go on. Go on, please.
Well, what's likely going to happen now is instead of accountants or payroll providers, people are going to use Claude or Chat GPT to figure out their overtime situation, and it's going to be a mess.
It's not a defense.
So I'll give you a real.
This wasn't an FLSA situation, but I literally had this situation that happened to me with a client today, whereby they said, "Oh, I'm negotiating a severance agreement. The person received outplacement assistance, and the outplacement coach tells my client, oh, when you're laid off, if you're laid off, then a non-compete is not going to apply to you when you're laid off." And I said, well, yeah.
What were you going to say, Chuck?
Yeah.
So, all right. So right now I'm dealing with an audit. I mean, and twice this year I've taken over audits. I don't want to get too explicit because they're current right now. I've taken over 2 audits from accountants. In one case, it was an overtime and minimum wage audit, and the accountant submitted maybe 15 pages of documents. I'm like, this is, and including like the main document was like a summary. I'm like, this isn't right. Because then the auditor came back, the agency auditing said, well, this is what we need. And so I started getting a document. So the accountant submitted 15 pages. I submitted more than 1,000 pages. So, I mean, that's a real world example of the difference between, I think, how an attorney looks at this and how an accountant might look at this. I think the accountant was trying to evade, any sort of scrutiny. I'm like, that's not going to work with these auditors. They're too experienced, and they know, they want to see raw data. And so the raw data was, a minimum of 1,000 pages. These are basically all the payroll records for the company. So I think that's a real world example of how this stuff works, and the difference, between, maybe how a CPA or an accountant will look at it versus us.
Yeah, I mean, I've this is still the craziest case in my career with a defendant who just actively destroyed evidence, but their lawyer, we've come to understand that it wasn't even a real accountant, it was a tax preparer who was like, well, if they can't find it, they can't prove it. And I'm like, that was the worst advice. That is literally the worst legal and non-legal advice I have ever heard given in one of these cases. It is the opposite of how actual wage and hour litigation works. It was horrendous advice. And you may have committed crimes at the behest of this non-accountant tax preparer who gave you bad suggestions and had no legal reason to do it.
It's a great example. Helen, what is all right? So tipped employees is another is another layer of this, right? I mean, and that's a controversial and hot topic nowadays. What is the tip credit, and what should employers know about these tip credits and like the tip pools?
Okay, so under the Fair Labor Standards Act, which by the way is going to have very, very different numbers, but I'm just going to use the Fair Labor Standards Act just as a general principle. But the calculations under the Fair Labor Standards Act are more likely than not going to be different than the jurisdiction where you are in. So don't use the numbers under federal law. Make sure you're using the numbers under your local law. But the general principle is that in a service business like a restaurant or a hotel where employees receive tips, it is standard that they receive tips. Under the Fair Labor Standards Act, you can pay a lower minimum wage. And again, don't use the number in the Fair Labor Standards Act because the federal number for minimum wage is lower than, I think, 48 of the 50 states in this country. My math could be a little wrong on that too, but essentially federal law is lower than practically every jurisdiction in this country. But the principle is the same. So under the Fair Labor Standards Act, if you're in that service business and the employees receive tips, then you can pay a lower minimum wage to that employee. Now, the employee still must receive minimum wage for all hours worked. So it is still the onus and burden on the employer to ensure the employee receives a minimum wage for all hours worked. So if it turns out that the restaurant is having a really slow day on a Monday and the employee does not receive with the tips at least minimum wage in the local jurisdiction for all hours worked, the employer must then make up that difference and make sure that the employee receives at least minimum wage for all hours worked. And there's also something else called a tip pool as well that employers can do. So for example, tip pooling is something under the Fair Labor Standards Act that allows employers to implement a system whereby, if let's say, I'm going to use the example of a restaurant, let's say other people should share in the tip too, not just the server. So for instance, the busboy or, other people who might clean the tables. All the tips go into a pool, and then those tips are distributed among multiple workers. There is a caveat to that. Managers and supervisors are not supposed to share in that tip pool if there is a tip pool. So if you have the situation where, let's say, you're short one day and the manager steps in and waits on tables, that manager still is not allowed to share in the tip credit because they're still generally a manager. So that's essentially the skinny on it. What's really interesting, though, that's playing out in a number of jurisdictions, especially the city of Chicago, is that they want to phase out this tip credit and require these service businesses to pay full minimum wage to the employees, plus let them keep the tips. And for instance, in Chicago, there was a phase in to get to, let's say, by 2028, the full minimum wage, which in Chicago is pretty high. I think it's like $16.60. That's pretty high. And I think business and others have been pushing back on it. So this tip credit was implemented and there's supposed to be certain phase-ins. Well, there's now talk of freezing it so that you don't get to that full minimum wage. And the interesting part of this whole situation that is playing out is that employees on both sides are on both sides of this issue. So you have employees who say, yes, we want this to be frozen because the mom and pop restaurants, or maybe even not the mom and pop restaurants, can't afford this. The cost of food has gone up too high, and they're going to shut down if you force them to pay minimum wage for all hours work, plus allow us to keep the tips. So don't keep raising, the minimum wage. Just keep it where it's at and freeze it. And then you have employees who are fighting this and saying, look, we deserve to get, paid. We should get these fair amount of wages, and let this, continue to be phased in such that all employees receive at least minimum wage plus get to keep the tip. So it's literally a fight going on right now in Chicago. I don't know if it's happening in other jurisdictions too. So it's interesting to see the one jurisdiction in particular where it started to phase in, to get rid of this tip credit. And I would say it might not necessarily be, working to the advantage of all employees that it's designed to protect in, let's say, the restaurant industry.
So let's follow up with something here, because you raise a really interesting point. And this is getting into a bit of a different sort of doctrine, though. Joint employer. So if a restaurant or a company decides to outsource its wait staff to a professional company that does, that provides waiters, servers, whatever.
Yeah.
I mean, what happens if that professional company, that third-party company, pays less than the minimum wage, or doesn't equally distribute tips, or something like that, or doesn't properly pay overtime? Can the contracting company be held liable still?
I think they can both be held liable as joint
Yeah.
employers. And then my educated guess is that those two companies are then going to duke it out. Because my guess is in their contract, they're probably going to have some sort of indemnification provision whereby if I'm held liable because of something you did or failed to do, then you better pay my attorney's fees and costs. And that is my educated guess as to what would happen in that situation.
I agree. I mean, I think that's generally what happens. And I think a lot of agencies support that too, or would go with that because they want as many deep pockets as they can get. So, um, what about waiver agreements? And I know we touched on this earlier, but I want to hammer this part home because
Yeah.
companies still do this. And I'll throw this out to all of you. Can a company use waivers in order to avoid liability or I guess to alter terms and conditions of employment?
This is something I actually touched on right in the very
Yeah,
beginning of this discussion when I talked about the whole strict liability aspect. Wages are one of those few areas of the law, and I'm talking about employment law specifically. The other might even be, sexual harassment or something like that, where you can't waive your right to go to court, for instance. But you cannot waive your right to compensation. You can't waive your right to workers' compensation benefits. You can't waive your right to unemployment. Any of those kind of waivers that an employer would ask an employee to sign, not only is it not worth the paper it's written on, but it could backfire against the employer for even asking your employee to sign such a waiver. But what I've seen done is because things like compensation and workers' compensation cannot be waived as a matter of law, what employers sometimes do is they try to backdoor it in. So if let's say you are separating an employee and you have them sign a separation agreement, you will have language in that agreement in which the employee acknowledges that they've been paid for all hours worked, they're not owed any compensation, they haven't suffered an on-the-job injury, for which they haven't reported or filed or whatever the case may be. So because employers know, or at least their lawyers know, that certain things can't be waived as a matter of law, they try to find a way to get in like this backdoor waiver by having the employee acknowledge certain things. And then the employee sometimes in a catch-22 because they really want the severance, but maybe they really feel they're entitled to a bonus and they feel they haven't been paid, all compensation to which they're entitled. And that's where that rub sometimes comes in when you're negotiating these agreements.
On that point, there's case law in Illinois appellate courts that an agreement that provides severance and tries to waive an earned bonus or other earned compensation is not enforceable. In fact, there was an executive who tried to carve out a bonus from the claim because he was like, I'm owed a bonus, so you can pay me the severance, but you can't take away my bonus. And the employer failed to do so, so the employee filed a claim, and the appellate court held the employee gets the severance and gets the bonus because you can't have an agreement that violates public policy. That's illegal. At the same time, though, you can have enforceable class action waivers. So that's a little bit different than having someone release their right to wages, which Helen's 100% right on. But the flip side is you can have someone say, or you can have a company have employees say they won't file class or collective actions, and those have to be individually litigated. But then oftentimes what folks like Max will do is then file like 1,000 of those individual claims wherever they have to file them.
Yeah, be careful what you wish for there. I think that move worked better when lead generation and the internet were less sophisticated. Now it's so easy for us to find plaintiffs when we really want one and we know that there's something illegal going on. We can either, whether it's a mandatory arbitration clause, a class action waiver, or anything else, we can arbitrate or claim somebody to death if we feel like it. Chipotle won a motion like that to compel arbitration, and the law firm, as a matter of principle, was like, F you, we're going to get every single one of these people. They hit them with so many arbitrations, Chipotle went running back to federal court begging to like undo what they'd won. So, it just, I think that the short version is try not to violate this law and play too many games with your employees, and you won't get sued for it, because the downsides are astronomical. And I guess one other practice point, you won't get insurance coverage on these. Like there's almost no way to insure your business against a wage and hour claim. I mean, Chuck, you do panel work, right? But like, I've never ever seen a wage, and I've seen one case in my entire career where some insurance company, for reasons I still don't understand, was covering a claim like that. Most of the time, employer practices liability insurance or EPLI does not cover wage and hour because it is a strict liability, usually black and white penalty. So you
And criminal
basically,
sanctions.
yeah, I mean, you'd essentially be acting as a line of credit on a business that's violating this law and just underwriting them getting caught for it when they inevitably get caught speeding. So that's not going to be an out either.
I so I don't want again, I don't want to get too explicit because this is current, but I'm dealing with an insurance covered claim right now where attorney's fees will be covered. It's for the wage and hour claims, attorney's fees will be covered, but not damages. So
Yeah.
that's an interesting wrinkle. I've never
That is
encountered that
interesting.
before, but and it's not an extra rider either for the policy. It's included in the policy. I guess
Is
it's
that
just a good
on
insurance company.
is that on both sides though? So if there is liability, does the policy cover the employee's
No,
attorney's fees? Okay.
only defense fees, only defense
Okay.
fees. An interesting wrinkle, but
Yeah.
I've first time I ever encountered that because typically, and so I've researched this before. Insurance companies won't indemnify or cover these wage and hour claims because of the criminal sanctions, and the theory is that they don't want to be seen as sanction or as encouraging criminal behavior. So take it for what it's worth, but that's what I found the research to be. Um, let's finish up with it, or let's try to get this one in. What if a business overpays an employee, needs to make a deduction for the overpayment or like wage garnishment?
hmm I think you've got to get the employee to sign that. I think you're running afoul of potential state and federal laws. I think under for example, just to stay with Illinois, the Illinois Wage Payment and Collection Act requires something being signed for the deduction. Otherwise, there can be liability for that. And so if there is an overpayment, either you've got to get the employee to sign something, or then you may have to, I guess, litigate it. But it's just risky, and it's probably not going to be worth the headache. Now, I understand, I think for some employers that can still that can impact a small employer or a small business, or if there was like an across the board payment made to a bunch of people. But at the same time, it's just not safe to just blanketly take money out of their paycheck.
Well, and under the FLSA, if let's say you do get the sign off, you still got to make sure that they're not falling below the minimum wage.
Yeah.
You know, sometimes companies in a lot of blue collar settings, right? Like companies will do things like they'll loan money to their employees, advance paychecks, and then they got to pay it back over time. But if you do anything like that, whatever the reason for the deduction, make sure in addition to the state law concerns that whatever the deduction amount is, you're not knocking them below the minimum wage or overtime rates with that deduction. They still got to hit the minimum thresholds for the time. It's not enough to say, well, they would have done it but for the loan that I recouped on or all of it. They still got to hit the federal minimum or state minimum if there's a higher one in your state.
Yeah.
What about a blanket waiver, that's contained like in the handbook where, we authorize the employer to deduct wages from our check?
I mean, at
No, that
least in
won't do.
Illinois, the wage payment and collection, and I realize this is a national webinar, most of at least in our state, it requires consent freely given in writing at the time of the deduction. You can't prospectively say, I authorize you to do it when it's not to the employee's benefit. Are they doing it for health insurance premiums and contributions? Okay, fine. That's to their benefit. Or you're doing it for withholding for state or federal legal reasons. Those are accounted for in our state law. But you're doing it for the employer's benefit, then these blanket statements don't work. And you also got to be aware of that in whatever other state you're in. I know Wisconsin has a wage act that is not a one-to-one, but has a lot of very close similarities in language and substance to Illinois'. Indiana's is a little bit different, and beyond that, you're sort of on a state by state.
I think
Well, there's
actually
a
most of
separate
the
issue there
states are
too.
similar to Illinois in that regard, but there's one wrinkle maybe we'll get to in a second. Sorry, Amit, go ahead.
Oh, the separate issue too is that a handbook may not be a contract in most states. So even just putting it as a handbook policy is not going to cover you. So it's still not a good best practice.
What you can do though, if let's say in the example of a loan situation whereby the employer does legitimately loan the employee money, and it's going to be a regular and systematic deduction, and assuming it complies with the minimum wage, et cetera, you can have the employee sign one time that the employee does agree to this amount to be deducted from all the future payments. You don't necessarily have to get them to agree to sign each and every time if it's going to be the same amount over a period of time, and this is agreed upon upon the time of the initial deduction. So that the law does allow for that. At least in Illinois, I can't answer with respect to other jurisdictions.
Any final thoughts? We're at the top of the hour, or just 1 minute at the end.
Talk to your lawyer, not your accountant, for wage and hour advice for all
Or
that
your
is going
AI.
to go.
Or your
And
AI agent.
classification. I would add classification to that too.
Yeah, I've seen that happen a lot relative to accountants or tax professionals who advise, just arbitrarily classify. Well, thanks everybody. That was really great. So we want to thank again our sponsor, National Law Review. You can find out more about them on slides 3 and 51 of the PowerPoint. And our next presentation is April 16th at 2 p.m. Central Time. It'll be our fourth of 7 in this series, leave of absence and medical issues. So we'll see you all then. Great discussion. Great job, everybody.
Thanks, Chuck.
Thank you.
Thanks, everyone.
Good to see Amit.
Yeah, thank you, Amit.
That was fun.